everybody. Hopefully you can all see and hear me.
Recording started.
Thank you for joining us today for our webinar on understanding the Employment Rights Act. And we'll also be presenting an immigration update for you as well. My name's Madeline Oakley. I'm a solicitor in the Employment Department, and I'll be taking you through the Employment Rights Act changes. And then I'll hand over to my colleague, Sohan Sidhu, who is a partner and head of immigration, to talk you through the immigration changes. So on our agenda today, we will be looking at an overview of the Employment Rights Act, looking at the day one rights that will be introduced, going through the unfair dismissal reforms, looking at the duty to prevent sexual harassment, changes to redundancy and collective consultation procedures, and also looking at extensions to time limits for bringing a claim. I'll also touch upon the establishing Fair Work Agency as part of the Act, fire and rehire, and looking at 0-hour workers. Throughout, we will be looking at the implications for businesses, and then an opportunity to go through some of the FAQs as well. So the Employment Rights Act of 2025, it is one of the most significant employment reforms of this generation, and its main purpose is to create a more equal landscape for employees, and aiming to improve living standards across the UK. The bill did receive royal assent on 18th of December 2025, and it's planned across a phased 2-year period where these changes will be implemented. So not everything is going to happen all at once. Overall, there are 28 proposals. But the government has committed to consulting extensively on the proposed changes. So we don't quite know exactly what everything will look like yet. And businesses are encouraged to have their say by responding to consultations and providing their views. Businesses will need to keep up to date with the changes, though, and adjust policies, contracts, HR processes to ensure that they are compliant. A key sort of theme is that non-compliance is going to become more costly for businesses. So just looking at some of the reforms in terms of family-friendly and statutory sick pay reforms, there is an introduction of some day one rights here. In terms of statutory sick pay, this is going to be paid from the first day of illness instead of the 4th day. At the moment, there's a 3-day waiting period, and also the lower earnings limit is going to be removed, and that was the minimum amount that workers must earn in order to be eligible. These changes are going to apply from the 6th of April, so fairly shortly. We've also got some changes to paternity and unpaid parental leave, and essentially introducing day one rights for this type of leave. So there are no longer any minimum length of service requirements in order to take these types of leave. And this change as well is effective from 6th of April 2026. In practice, probably unlikely to cause significant disruption. Unpaid parental leave uptake is quite low, probably because it is unpaid. And then in terms of paternity, whilst eligibility to take the leave has been expanded, the actual pay for the leave itself remains one that requires a qualifying period. So the pay is dealt with differently and requires 26 weeks of service. The leave itself is only 2 weeks of leave. So again, not expected to have sort of major consequences of these day one rights, but employers will need to be aware of the changes. There is going to be an introduction as well of unpaid bereavement leave, which will be from day one, but this is now expected at some point in 2027. The current position is that eligible employees are entitled to 2 weeks of leave following the death of a child under the age of 18 or a stillbirth after 24 weeks. But there's no sort of broader range of rights for the death of a loved one or indeed a miscarriage before 24 weeks. So the Employment Rights Act will be changing that. Employees will be entitled to a day one right to unpaid leave following the death of a close relation. We don't know exactly what the definition of close relation will be, but it's likely it will be mirror time off for dependents or carers leave. So looking at spouse, civil partner, parent, child, or someone living in the same household. The Act doesn't mention whether this will be paid leave, and that may ultimately impact on how widely it is used. There is also plans for stronger protections from dismissal for pregnant employees and those returning from maternity leave. There are existing protections against dismissal, but they will expand upon these, and the government has launched a consultation in respect of this, but the results haven't been published yet, and that part of the Act is expected in 2027 at some point. As you'll see, the changes are implemented at different stages, depending on the phases of the Act. So statutory sick pay, paternity, parental leave are all with effect from April of this year. Unpaid bereavement leave and dismissal protections are expected in 2027. In terms of the overall impact on businesses, there is a broader shift towards inclusive and secure workplaces. There is an increased responsibility to manage leave, flexibility, dismissals fairly and lawfully. HR will need to look at updating contracts, policies, and also manager training to ensure compliance, and making sure that the review is taking place before these changes come into effect. Payroll systems as well would need to be updated to ensure that they are compliant with the new statutory sick pay rules too. So one of the larger reforms are the changes to unfair dismissal. Currently, for a claim of ordinary unfair dismissal, employees would need to have 2 years of continuous service with their employer. The Employment Rights Act is going to reduce this quite substantially to 6 months of qualifying service, and also introducing uncapped compensation as well. This means that employees can potentially seek compensation for more than a year's loss of earnings, and no upper threshold. So at the moment it is up to a year's of earnings, up to the statutory maximum, which is £118,223. The Act is also applying retrospectively. So these changes are taking effect from 1st of January 2027, but it will apply to people who have attained 6 months of service at that point. So technically, someone that is employed from July of 2026 would gain protection from unfair dismissal on the 1st of January 2027. So something to certainly be aware of and take note of. In terms of the actions that employers would need to be taking, contracts and policies should be updated. A very common probationary period is expressed as 6 months. Employers will likely want to reduce this to below 6 months to ensure that probation is dealt with before the employee gains qualifying service requirements to bring a claim if they were dismissed. Probation strategies also need to evolve, with it being reduced to just 6 months. Sort of a light touch approach to early performance is probably not going to be enough anymore. Decision-making processes should be tightened, and every decision to dismiss should have a clear rationale and stronger procedural fairness. In terms of documentation, a paper trail is going to matter. Employers must be able to demonstrate the reasons for the decision that they took, documenting their concerns, reasonable opportunities to improve, and there is an increased financial risk for employers who do face dismissal litigation with the uncapped compensation. Something to bear in mind, sort of risk exposure at the early stages if a claim is made, to understand what the potential compensation could be payable to the claimant. We have got changes to the duty to prevent sexual harassment as well through the Act. As it currently stands, employers have a duty to prevent sexual harassment in the workplace by taking reasonable steps. So there is a reasonable degree of proactive preventative action to be taken. Steps are usually including risk assessments, policies, giving regular training, having reporting procedures, and taking action if anything is reported. The Act is going to strengthen this duty and take it to being to take all steps reasonable to prevent sexual harassment. So it is increasing that duty. It's going to be much harder in practice to successfully defend a harassment claim. Rather than taking the bare minimum approach to safeguarding employees, employers should be advised to basically put in place whatever is possible. There is likely to be a sort of difference in standard in businesses depending on their characteristics, obviously the size, resources available. However, it is recommended investing in best practices to avoid costly consequences of falling below the standard, which is introduced by the bill. Third parties as well, employers will now become directly liable for harassment perpetrated by third parties, which can include clients, customers, and contractors. So policies and other regulatory mechanisms must reflect this new potential liability. Employees can't bring a standalone claim for third-party harassment, but employers should still take this seriously, as the Equality and Human Rights Commission can take enforcement action. In terms of whistleblowing, there are changes here that sexual harassment that has occurred or is likely to occur or is occurring may form the subject of a protected disclosure, and they would be protected from dismissal or detriment from raising that disclosure. Non-disclosure agreements as well, which restrict reporting or discussing sexual harassment in the workplace, will become automatically void under the changes. The only exception would be where the worker agreeing to that non-disclosure agreement has obtained independent legal advice and has therefore given fully informed consent. These changes are expected October of this year. In terms of action required, quite extensive here. Update and communicate your policies, review and refresh anti-harassment policies that define harassment, and including looking at that third-party liability as well. Explain your reporting mechanisms and asserting a zero tolerance stance. There should be accessibility and visibility in the workplace to reinforce proactively the anti-harassment training. So looking at your intranets and regular training to employees. Employers should look at carrying out proactive and detailed risk assessments to identify the risks. And this will need to be done again. So if you've already done them, look at them again in the scope of taking all reasonable steps now. Look at any high risk settings. So in particular, you could look at people who are working alone, business trips, social events, and interactions with clients or contractors, and document ways to avoid or put in place mitigation strategies. Training should be mandatory, and looking at delivering tailored additional modules for managers in terms of handling complaints as well. There should be trustworthy reporting mechanisms so that there is confidential and anonymous ways and channels for reporting, ensuring that complaints are logged, ensuring they're investigated, and also tracking, looking at any patterns as well. So the key things are monitoring, review, leading by example, potentially regularly surveying staff as well, and ensure that senior leaders are visibly backing a zero tolerance policy. And it's not just the financial consequences or risks associated with tribunal claims. It can also have significant damage as well to brand or reputation, particularly in the age of social media as well. So just looking now on redundancy and collective consultation, we are expecting some changes here. In terms of the triggers for collective consultation, they are going to be tightened. Currently, there is a duty to consult collectively if the business proposes to dismiss 20 or more employees at one establishment within a 90-day period. There is still going to be this rule of the one establishment test for collective redundancy, but there'll be a new separate trigger point which is introduced as well by the Act, which will create a trigger point for redundancies across the whole of the business rather than just looking at a single site. And we're looking at these changes by 2027, at some point in 2027. We don't know yet what the figure will be, what the number is, that on aggregate would amount to a collective consultation. But for businesses with multiple locations, looking at your retail chain providers, care providers, it does mean that smaller rounds of redundancies at different sites could then on aggregate trigger that collective consultation requirement. And failing to consult properly can lead to claims for unfair dismissal. The consultation itself must begin in good time. There are certain minimum time periods that apply depending on the scale of redundancies that are proposed. So if we've got 100 or more redundancies, consultation must begin at least 45 days before the first dismissal, or fewer than 100, the minimum period is 30 days. In terms of claims for a protective award, so this is changing as of April this year. If you fail to consult properly on a collective redundancy, claims can be made to the tribunal for a protective award, which is currently 90 days gross pay for each employee that's covered. So it is a very expensive liability for employers, and the purpose of it is to punish, to penalise the employer for not complying with their obligations. As of April this year, it's going to be doubled to 180 days pay. So legal compliance in redundancy is essential, and making sure that consultation takes place where it needs to, as that failing to consult can become much more costly. Just a note now on the tribunal time limits. So these are being extended as well. They will be, so currently most claims you need to bring a claim within 3 months less a day to the employment tribunal, but the Employment Rights Act will be extending this to a period of 6 months. And the changes do apply to a wide range of claims, so unfair dismissal, discrimination, redundancy pay, and it basically means that the threat of litigation is going to hang over employers for twice as long after an employee departs. This is also coupled with the fact that the ACAS conciliation window has also doubled from December of last year, from 6 weeks to 12 weeks. So to bring a claim, an employee will need to bring a claim in time, but also they need to have contacted ACAS. They don't have to engage in early conciliation, but they need to at least get a certificate. And the effect of early conciliation is that it pauses the clock for when you need to lodge your claim at the employment tribunal. And that window that the clock is paused for is now 12 weeks as well. So the effect of all of this just means that risk exposure is increased, and the length of time that something could potentially hang over you and not knowing whether a claim has been brought or not has effectively been extended quite substantially. The Fair Work Agency, this is a new enforcement agency that is being established from the Act. It is due to be established on 7th of April, but we don't expect it to be up and running completely by that date. It is going to take over areas that were previously overseen by other agencies. So looking at things like national minimum wage, employment agency rules, modern slavery offences, but it's also going to take on new responsibilities as well. One of the key ones is enforcement of statutory holiday pay. And there is also scope for the government to expand FWA's power and remit in the future. So in terms of its role, it's not just what it covers, but it will be the powers that the Fair Work Agency has. It will be able to demand information from businesses. It will be able to enter business premises, can even seize documents, and it can issue notices for underpayment, requiring employers to pay what is owed within 28 days, and it can impose financial penalties of up to 200% of the unpaid amount, capped at £20,000 per worker. Penalties can be reduced if paid promptly, but they are still quite substantial. There is also an introduction of criminal offences attached to non-compliance. For example, knowingly providing false information or obstructing an investigation could lead to fines or even imprisonment in some circumstances. If company leadership is found to have consented or neglected these breaches, they can also be held personally liable as well. One of the significant changes is around holiday pay. Until now, that hasn't really been enforced by any state body, and it is quite a complex area in terms of calculating the statutory holiday. So many employers have sort of taken a wait and see approach to compliance, but the FWA will now be able to investigate and penalise employers who fail to pay holiday pay correctly or who don't keep proper records. Records must now be kept for 6 years, and the same goes for statutory sick pay as well. Previously, HMRC could determine whether statutory sick pay should have been paid in a dispute, but there wasn't really an enforcement mechanism, and then that's something that the Fair Work Agency can bring under its remit. The FWA also will be able to recover its own enforcement costs from non-compliant employers. We're not too sure exactly what that will look like yet, whether it would be a fixed rate or whether it would be based on an hourly rate, but that is on top of any penalties and back pay owed. So non-compliance is going to become even more expensive under this regime. The FWA will also have the power to bring tribunal claims on behalf of workers who aren't pursuing them themselves, can also provide legal assistance in employment-related civil cases, including representation. Whilst it is being established on 7th of April, we're not necessarily expecting it to be fully operational, but it is important to start preparing now, particularly around holiday pay compliance. For businesses, I think the biggest thing to take away here is that enforcement is becoming more proactive and more powerful. There is a shift away from sort of individual enforcement through tribunals and shifting that towards centralised enforcement. So employers will need to be aware of the FWA and its scope, its remit, and what the enforcement powers are of it as well. So just looking at fire and rehire practices and the changes we've got there, we're expecting this January 2027. Fire and rehire labels the practice in which employees are dismissed and re-engaged on new but less favourable terms. There's similarly the concept of fire and replace, where they're replaced with others on less favourable terms. And it did receive widespread negative press in recent years following some high profile cases. Most notably, we had the dismissal in 2022 of almost 800 employees from P&O Ferries and their replacement by lower paid agency staff. So that's where the sort of catalyst for reform in this area has come from and has influenced the Employment Rights Bill and now Act, specifically on the restrictions of fire and rehire or replace, and the changes to redundancy consultation, which we've covered. The changes do mean that if an employee rejects a restricted variation to their employment contract and they are dismissed, their dismissal will become automatically unfair and can also lead to a 25% uplift in compensation. Restricted variation may include changes to pay, so that can look at bonuses, hourly rates, commission and annual leave. Could be to do with working time, reduction in the hours, or changes which would affect work-life balance, and also flexibility clauses, which enable the employer to vary terms unilaterally. Additional restricted variations may be defined later as well in secondary legislation. So we don't know exactly yet what it would look like. There are potential exceptions. So a dismissal may be permissible if the employer can show that they were under calamitous financial distress, and that the dismissal also meets the standards of the general fairness test in terms of how the dismissal was processed. So some quite significant changes here. They have been, originally they were set to come in to play October 2026, but they have now been pushed back to 2027. So something to watch out for in the future. We also have changes in protection for 0 hours workers and also low hour workers. So there are existing rights that basically mean workers on 0 hours contracts are not treated less favourably than their full-time counterparts, and exclusivity clauses have been prohibited as well. The Employment Rights Act will strengthen those protections for 0 hour or low hour workers. And for low hour workers, it will be where the guaranteed hours fall below a certain threshold. The rights themselves won't apply to everyone. There will be a concept of an excluded worker, and that will generally be, we anticipate, genuinely self-employed individuals and contractors, possibly some agency staff. The changes will mean that as of 26 weeks of service, a worker on a 0 hour or low hour contract will be able to formally request a more predictable working pattern. And this is particularly relevant where someone consistently works more hours than what their contract is guaranteeing. And employers will have a duty to consider the requests and respond within a set time frame. There are also changes that mean that employers will need to provide reasonable notice of shift changes. So this is in response to common issues of last-minute rescheduling that makes it difficult for these workers to plan around their lives and creating stability. And they will also be entitled to compensation if there is insufficient notice given. There will also be protection for dismissal or detriment for those who exercise their rights to request a more predictable working pattern. in terms of what this means, it doesn't mean that 0-hour or low hour contracts are banned. So it doesn't eliminate completely the flexibility there. There's no outright ban on it, but it's more of a rebalancing of rights, so that the flexibility isn't so one-sided towards employers. So employers will need to review their existing arrangements, and look at a more structured approach to managing casual and low workers, being aware of their rights, and the response timeframes, if a request is made for more predictable working pattern. Just so some final notes here on the Act. So as you can see, the reforms themselves are quite extensive. We haven't had the opportunity to go through absolutely everything today, so it's important to be aware of other reforms. So we have got quite substantial trade union reforms, strengthening rights of trade unions, and strike action. Also tipping law changes as well. Employers, we'd recommend that you follow the plan to make work pay implementation timeline. So this is the government timeline for when they plan to implement the phase changes across a 2-year period. We have already seen previously that dates have been amended, so it's important to take note of that and see if there are any changes. Employers will need to act now to update policies, practices, and procedures, particularly around unfair dismissal and probationary periods, to make sure that they're up to date when these changes come into effect. If you are facing a claim, consider potential risk exposure early on under the uncapped regime as well. So thank you for listening. We did have a couple of questions in advance. So I'll just go through those now. They were to do with unfair dismissal and those changes. So someone has asked about fixed term contracts, say for over 6 months, because that will be the new qualifying period, and how would employment be ended? It will mean that if you have got a fixed term contract which is for more than 6 months, the renewal, the expiry of a fixed term contract without renewing it is counted as a dismissal. So if they have achieved 6 months of service because their fixed term contract was for longer than that, the normal rules of unfair dismissal will apply. And the question will be, why was the contract not renewed? And whether the reason for that was a potentially fair reason. So it could be redundancy, the role's not required anymore. The tribunal will then consider whether or not the employer has acted reasonably in terminating the contract for that reason. So just because the fact that it is a fixed term contract doesn't give an additional defence to unfair dismissal, you'd still need to follow a procedure. Somebody else has asked about the changes within, so the 6-month qualifying period, and if a employee is, say, off for a substantial period because of, say, sickness, is there an option to extend the qualifying period to reflect this? The answer is no. They will still obtain the rights as of 6 months. It doesn't mean necessarily that an employee can't be dismissed. And you could still look at extending the probationary period if you have the contractual right under the contract, but it doesn't mean that there's protection if you did ultimately dismiss them just for purely that reason alone. So you would still need to look at all of the circumstances and whether the dismissal was fair or not. In terms of documentation, one of the key things is to record your reasons for why dismissals are made. So even before the 6-month qualifying period, whilst they won't have a right to bring a claim for ordinary unfair dismissal, if, say, an employee brings a claim for discrimination instead, there are no qualifying service requirements that are required for that. So if you don't have any paperwork, it's a little bit harder to show why you took the decision to dismiss, i.e. defending like it wasn't for a reason that amounts to discrimination. So it's so important throughout to still have a paper trail in place. Thank you for listening, and for those of you who have submitted a question, I'm now going to hand over to my colleague Sohan, who will be talking you through the immigration system and what changes we are facing.
Thank you very much, Maddie. Good morning, everyone. Thank you for joining us today. My name is Sohan. I'm part of the immigration team here at Ellison Solicitors. I'm going to be spending about 10 minutes or so talking about the sponsorship and employment of international workers. And we'll have sort of a canter through sponsorship licenses and the employment of skilled workers. We'll also look at compliance duties and responsibilities, including right to work checks. We'll look at graduate visas, which are unsponsored visas, and we'll have a brief look at the potential changes on the horizon, which may even be coming into effect from next month. As I'm going through the presentation, you'll see there's a common theme here with the Home Office, and the common theme here is one of money. Immigration and the sponsorship of migrant workers is a fairly expensive exercise, but we'll be looking at the kind of numbers and things as we're going through the presentation. In terms of the current immigration landscape, as we know, end of EU free movement following Brexit, all nationalities are now treated equally. No preference is given to EU nationals. UK employers must hold a sponsorship license to hire from abroad, and the immigration system is points-based and very compliance-driven, and we'll be looking at the compliance angle shortly. In terms of hiring skilled workers, the essentials: number one, the employer must be in possession of a Home Office sponsor license. To obtain a sponsor license in the old days was a fairly straightforward process. You obtain a license and the Home Office can ask questions later. Fast forward now, the sponsor license application is very, very front loaded. First question being, why do you actually need a sponsor license? Do you have somebody you're looking to employ? Are you looking to have the benefit of a license to be able to employ international workers? The application itself is, you can probably distill it down into three stages. You have an online application. You have supporting documents to confirm the business has got a trading presence in the UK. And you've also got something called the Appendix A. The Appendix A is a list of mandatory questions. And as I say, the first question is, why are you looking to apply for a license? If you've identified a particular international worker, the Home Office will want to know their full details. They also want to know the job title, which you're going to allocate to the person, their salary, job description, how you've actually come to know them. There is no technical requirement to have a resident labour market test, but the Home Office can still ask questions about how you've come to know of that person. So it's very important to retain all relevant documents, interview records, CV, interview notes, that kind of thing. Once the business has got a sponsorship license, important to bear in mind, it has no expiry date. In the old days, the license was valid for 4 years, subject to renewal. Then I think the Home Office briefly went through a period where they were granting licenses for 10 years, but currently there's no end date. Once the license application has been approved, the next step would be for the sponsor to assign something called a certificate of sponsorship, which is essentially an electronic document. And the certificate of sponsorship will focus on the individual in question, their personal details, and also details about the role, for example, the information given in the sponsor license, job title, salary, job description, that type of information. There are essentially two types of certificates of sponsorship. There's a defined COS and an undefined COS. Very, very broadly, defined COSs are to be assigned to migrants who are applying for visas from abroad. undefined COSs, very broadly, are to be assigned to people who are already in the UK, perhaps switching immigration status or moving from one sponsored employer to another. Once the COS has been assigned, the employee applies for their skilled worker visa. If they're abroad, they'll be applying for a visa from abroad. If they're in the UK, they'll be filing an in-country switching application. And I mentioned at the beginning a common theme with the Home Office in terms of money. To obtain a sponsor license, the Home Office application fee could be in the region of about up to £1,600. Processing times for a sponsor license generally are about 8 weeks, but upon payment of a fee of £750, you can expedite the application, and Home Office can potentially make a decision within 10 business days. To assign a certificate of sponsorship, there is a fee of £525, and at the same time a COS is assigned, the employer is also required to pay the immigration skills charge unless they're exempted. And the immigration skills charge can be up to £1,320, and that's payable per year. So if the sponsorship, for example, is going to be for a 3 or 5 year period, it'd be £1,320 times 3 or 5 years. I've mentioned there meeting compliance and reporting duties. It's important to bear in mind that the Home Office take the view that once you're in possession of a sponsor license, it is a privilege and not a right. And with that privilege comes fairly onerous compliance duties and responsibilities. And kind of classic things which we see are somebody's obtained a license, they've assigned a certificate of sponsorship, the worker is happily working for them, but there could be a change in their job title, there could be a change in their job description, which means potentially there's a separate application to make. That could require an application be made to the Home Office before any internal change takes place. So there are quite heavy compliance duties which employers need to be very much aware of. Looking at the skilled worker visa and the graduate visa, from the 22nd of July 2025, the skills threshold to sponsor a migrant was increased from A-level to graduate level. Now that doesn't necessarily mean the skilled worker must hold a degree or the job requires a degree, but if the job doesn't require a degree, the job will be pegged at the level where you'll probably expect the person to have probably around 3 years graduate level experience. The employer is required to pay a specific salary. The salary cannot be below £41,700 per year for a 37.5 hour week, or whatever is noted in the job code, whichever is higher. When I say the job code, the Home Office have basically allocated a job code to every job under the sun, and we have all the job codes listed on the Home Office website under various tables. The first thing we would do as advisors is hone in on whether the job actually meets the criteria for sponsorship. Is it a graduate level? And is the salary which the sponsor looking to pay, does it meet the actual job code? Whilst the skills threshold is now graduate level, there are still some roles which are eligible for sponsorship, which are below graduate level, and they could be technician level roles, and they're contained on something called the temporary shortage list and the immigration salary list. The salaries noted on the Home Office website generally are for a 37.5 hour week. If the sponsor is looking to, if they work towards a different working week, for example, maybe 40 hours a week, the salary will need to be prorated. There is an English level which migrants must meet, and it's set at level B2 of the Common European Framework of Reference. B2 is a fairly high level. It's regarded as being equivalent to A-level English. And for skilled worker migrants, they need to pass a 4-facet test, so their ability in speaking, reading, writing, and listening is assessed. We also have the graduate visa. This is an unsponsored visa, valid for between 2 and 3 years, subject to whether the migrant has graduated with a bachelor's or a master's or a PhD. Although currently the graduate visa is between 2 and 3 years, it will be limited to 18 months from January next year to graduates. Again, a common theme of money running across the Home Office spectrum is very heavy visa fees for those applying for graduate visas, for those applying for skilled worker visas. We also have the NHS health surcharge, which is £1,035 per year per family member. So if there is a graduate visa holder with a spouse and 2 children, they're looking to pay £1,035. For adults, there is a slightly reduced fee for children. These payments are paid upfront in one go before payment is made for the visa application itself. Looking at compliance and employer duties, we're all aware of the employer's requirement to conduct right-to-work checks for all employees. And to emphasize the point, all employees, that would include British citizens, and we have come across situations where employees take the view that they're more concerned about international workers and migrant workers rather than conducting checks across the board. That won't work in terms of the compliance requirements. When a job offer is made, it can be conditional upon satisfactory right-to-work checks. That's okay. There's also the requirement to maintain accurate employee and visa records. And the Home Office position is that the employer must have robust HR systems in place. There's a requirement to report changes to the Home Office within required timescales, generally within 10 business days. So the earlier example I gave, if a migrant is changing their job, for example, they could be promoted from a software developer to a tech lead, that potentially could cause that person being moved into a different job code. If it's a different job code, that will require a separate Home Office application being made and approved before that internal change could take place. And we do come across cases where employers have changed their employees' jobs without seeking prior authorization from the Home Office. We have civil penalties, which can be up to £60,000 per illegal worker imposed by the Home Office. And Maddie made the point of the Fair Work Agency having fairly onerous powers and the ability to issue penalties of £20,000. So by comparison, the Home Office are probably more aggressive in their arsenal in terms of what they can do to pursue what they regard as rogue employers. Civil penalties of up to £60,000 if they take the view that an employer has knowingly employed a migrant who does not have permission to work in the UK. Potentially there could be criminal implications as well. Common pitfalls and how to avoid them. Once the business is in possession of a Home Office sponsor license, they can be subjected to a compliance visit. The compliance visit can be announced or unannounced. In our experience, generally it's announced. So the Home Office would send an email to the authorising officer, key contact, explain that they're looking to do a compliance visit. Could be face-to-face, could be desktop via Teams or Zoom. Classically, what we find for a compliance visit is undertaken. The compliance officer will probably request certain documents from the business, maybe pay slips of the migrant workers, a hierarchy chart, just to see where that migrant worker or workers sit, possibly contracts of employment, just to assess those before the compliance visit takes place. We've come across cases where the compliance officer will ask the business, well, you've got all your employee data on a single laptop. What would happen if that device is lost, if it fails? Is it backed up anywhere? Do you have other systems which can be accessed to retrieve that information? Untrained staff missing compliance duties, key staff changes. We do come across cases where a business in possession of a sponsor license does have or did have an authorizing officer, a key contact and a level 1 user, but there could be changes in key personnel. Maybe people have left the business or they've been assigned to different duties. And lo and behold, we discover that the business doesn't have an active authorizing officer or a key contact or a level 1 user, and that's a breach of the sponsor license. The sponsor license criteria is that at all times there must be an authorizing officer, there must be a key contact and a level 1 user. Best practice from the Home Office perspective is to have at least 2 level 1 users. So just in case somebody who is a level 1 user is on leave, on holiday, and something needs to be done, maybe a report needs to be made via the SMS sponsor management system, at least there's a second level 1 user who can do that. We've come across situations where there are outdated contact or visa details held by the sponsor, and it's quite important again to emphasize the point that the Home Office position is that the business has a robust HR system in place. Now that doesn't necessarily mean there's an expensive, sophisticated electronic system, but there needs to be a system in place. Some of our clients are very small, some are very large, some have quite rudimentary HR systems, some have very sophisticated systems, but the point is to have a system which works, which is updated, is the key. Very, very important to have processes in place to track visa expiry dates. So if we know that a migrant's visa is expiring on, for example, the 1st of June this year, what systems are in place to remind that person to make an application and to also keep the sponsor updated? Are there diary reminders 6 months before, 3 months before, a month before, a week before? So there's not really going to be a situation where the person's visa expires and an application hasn't been made. To aid with that, we find sponsors sometimes use compliance checklists. They have internal audits regularly. They check in with their colleagues as to any changes in their personal details, email, mobile number, home address. The Home Office could ask a legitimate question. Well, if your migrant worker doesn't come into work, what would you do? Day one, would you contact them? Would you email them? After a few days, would you even go and visit their home address? Do you know what the home address is? Is all the information kept up to date? In terms of next steps, review your right to work procedures. Important to bear in mind that right to work documents should be retained for 2 years after the migrant has left the employment, irrespective of what any internal kind of rules and procedures the sponsor may have, including GDPR regarding destruction of documents. The Home Office requirement is 2 years post-employment ending. Consider the April 2026 immigration rule changes. There are proposed some very, very significant rule changes which were going to be introduced next month, but now we understand from the Home Secretary, Shabana Mahmood, that the changes will be implemented piecemeal. And I think the Home Office at the moment are focusing on the asylum process, asylum procedures, asylum seekers generally. Other changes which are likely to be significant to sponsors and migrants generally are likely to be introduced piecemeal over this year. What we know at the moment, currently skilled workers are on a 5-year journey. Once they've complied with the rules and they've had a possession of a skilled worker visa for 5 years, they can be eligible to apply for indefinite leave to remain. And we do know that the Home Office is moving away from the 5-year journey onto a 10-year journey. The Home Office are consulting on something called earned settlement. So there could be processes where if somebody meets an earned settlement criteria, they could be on a quicker journey to indefinite leave to remain. And essentially what the Home Office are doing, they're working towards tax bandings. So if somebody is paying the higher rate of tax, £50,000 or thereabouts, and they've been earning that salary for 3 years, they could potentially get a 5-year discount on the 10-year journey to bring them back to applying for, or at least being eligible to apply for indefinite leave to remain after 5 years. If somebody is an additional high rate taxpayer, earnings of £125,000 above, potentially they could receive a 7-year discount on a 10-year journey if they've been earning that salary for 3 years. I mentioned earlier that we've got the TSL, temporary shortage list, and the immigration salary list. They are for lower skilled positions, and the Home Office position is that if a sponsor assigns a certificate of sponsorship to somebody on a lower skilled job code, their journey towards indefinite leave to remain could be up to 15 years. also important to bear in mind that if a sponsor does assign a certificate of sponsorship to somebody on a TSL or ISL job code, it precludes that person from sponsoring family members, spouse and or children. So there are quite strict criteria around that. Hopefully you found that helpful. This is just kind of a very brief canter through immigration. Thank you for your time, and I should now put you through back to Emma. Thank you.